Hello and welcome to a MOOC on Media Law and Ethics. This particular MOOC talk about the Copyright Act of 1957. To begin with, I will tell you a small story about a court battle that related to this particular presentation. That was a popular sculptor of India called Amarnath Sehgal. He filed a case against Union of India. I have to tell you a small story about this. It was in 1956 when Vigyan Bhavan was created in Delhi. So, the then Prime Minister Jawaharlal Nehru, he wanted to have a good mural to decorate the halls of the lawns and halls of Vigyan Bhavan. He invited artists, and one such artist was Amarnath Sehgal. So, he was asked to produce a huge mural so that can be placed on the walls of Vigyan Bhavan. So, he was asked to produce that. He took a lot of time and he produced a mural, and that was 40 feet length and 140 feet height, such a huge mural, and that was placed on the walls of the Vigyan Bhavan. It decorated, it was well received, and the government paid him the money, and there was a contract, and he returned the contract to the government by assigning the every rights of this mural. So, the job was over. He was given the job. He created the mural was placed in the Vigyan Bhavan. He assigned the entire rights to the government of India. After about 20 years, the Vigyan Bhavan was completely renovated, and the walls and everything was painted. At that time, the mural was withdrawn from the wall, and that was sent to the stores, but it was never replaced, it was never put up on the wall. It came to the notice of Amarnath Sehgal, and about after 10 years he went to the court saying that my creation was not properly honored. So, I should be given compensation and that should be properly put up on the wall. Now, this is the case. I will tell the result of the case while concluding this particular lecture, and you have to think about it. You have to think about how this can be connected to this particular act, right, 1957. So, 1957 Act is Copyright Act. It talks about the creator's right and everything. Before entering into the presentation, I will tell you another history of the copyright. If you look at the history of copyright in the entire globe, it started with the invention of the printing. Only when the printing was invented, the art of copying by hand has been stopped. Until then, that was the only medium that you have to copy it something from the only use your hand. So, mechanical reproduction was started only with the invention of the printing. So, until then there was no such thing. Particularly in India, we were known for copying from the sources, copying from some original text to make multiple copies. One such person was Mahavidwan Meenakshundram Pillai. He lived in 1815 to 1876. During that period he lived, and he was known for copying Thirukural from one manuscript, one palm script into 3 copies. So, he was very popular because he was able to copy so many things which was used by the humanity. So, in India it has never been considered as a copyright. We were always created knowledge only for the consumption of the public, consumption of the larger good, and we had never had the habit of copying, call it copy, calling it a violation, nothing. We have never thought about it. But in 1847, when the East India Company, they promulgated Copyright Act that called it, actually the Home Office was mandatory for enforcement of rights under the Act. Because when the printing came into the country, lot of mechanical production started, and who is the owner, who is people having that could not be distinguished. So, the act was introduced in 1847. The second phase was in 1911 when British Parliament, the UK Parliament, they introduced another act in 1911, and subsequently that was introduced in India also. That called it as a criminal offence. If you copy something, then it has become criminal offence in India. The third phase came in 1957 after the independence India, that a lot of international conventions came. One such a convention is Berne Convention. The Berne Convention has some kind of provisions that made the copyright more tough. So, the Berne Convention has 3 basic principles. The first one is actually copyright is territorial bound. It cannot transcend the borders and sovereign borders and other things, right. So, the Berne Convention insisted that the first principle of Berne Convention is that this particular Copyright Act cannot be controlled within the territory of one country, right. That was the basic idea of the Berne principle. So, beyond territories, the art of work has to be allowed. So, by having national consensus, when you have international conventions, covenants and agreements, then you have to honor my book and I have to honor your book. So, automatically copyright has been extended beyond territory. That was the first principle of Berne Convention. The second one is automatic protection. That means that protection must not be conditional upon compliance with any formality. If you want to have copyright, you need not have any kind of formality. That is the second convention of the Berne Convention. And the third principle of Berne Convention is independence of protection. Protection is independent of the existence of protection in the country of the origin of the work. Whether your country has a copyright law or not, if you are a signatory to Berne Convention, then you have to honor this particular thing. That is the third one. So, if you ask me to define copyright, I have to tell you something about what is the basis on this. Copyright is a state guaranteed right given to creators of literary and artistic works. So, it is being given to the literary works and artistic works to protect their intellectual production or intellectual work. So, the term work includes a wide form of intellectual creations including text, photograph, diagram, maps, movies, sound recording, everything. So, if you want to be eligible to apply for a work, then the work must be original, it should be individual and it should be singular and it should be new. It should not be a copied from somewhere, right. When it is new, then you can apply for a copyright thing. So, copyright is a bundle of rights. It enables the copyright holder to print, publish, distribute, sell, lease copies of work and allied rights, which means that translation and other rights. So, 1957 was the major act came into India and that has been amended few years back. So, the present act that we have been following is Copyright Act of 1957 and we also follow the International Copyright Order 1999. So, international order that govern the copyright related rights in India. These two things, one is Copyright Act 1957 and International Convention in 1999. So, the original act has 15 chapters and 79 sections, but copyright is the Government of India domain. So, only Government of India, it has a section called 78. The Act, the 78th section of the Copyright Act enables or empowers the Government of India to make law. It is empowered to make rule by its notification in the official gazette for carrying out purpose of this act. And international conventions like Berne Convention, as I told you, that was in 1886. So, though it was signed in 1886, that is actually the binding convention, that is the first major international instrument to control the copyright thing. And the second one is Universal Copyright Convention of 1952, when India was just had the independence, that was enabled, that was actually promulgated globally and India was a signatory to that. And the WIPO, we had the TRIPS, that is called Agreement on Trade Related Aspects of Intellectual Property Rights. So, these were the major things. India had ratified the WIPO Copyright Treaty in 1996 and WIPO Performances and Phonograms Treaty in 1996. These were all actually honored only in the year 2018. This is the basis on which, so with the international conventions and Indian acts and with so many amendments, India is governing its intellectual creations in the form of various acts.